Are oral agreements legally binding? When you shake hands on a deal without putting anything in writing, can you actually enforce it in court? The answer might surprise you. Oral contracts are generally just as enforceable as written ones, with some important exceptions. For a contract to be valid, it needs 3 essential elements: an offer, acceptance of that offer, and consideration, which means each party takes on some obligation. If your verbal agreement includes these elements, it can be legally binding. However, enforcing oral contracts comes with time limitations. The statute of limitations varies significantly by state. In California, you have just 2 years to file a lawsuit for breach of an oral contract. Texas gives you 4 years, while New York allows 6 years, the same as for written contracts. Illinois provides 5 years, which may include contracts with both oral and written components if the verbal elements are substantial. Remember, this countdown starts when the breach occurs, not when you made the agreement. Wait too long, and even a valid oral contract becomes unenforceable. Proving an oral contract presents unique challenges. Without documentation, you're relying on memory, which can fade or be disputed. Witness testimony becomes crucial, but courts scrutinize witness credibility carefully. Misunderstandings are common, with each party potentially recalling different terms. And without written evidence, proving that someone fulfilled or failed to meet their obligations becomes particularly difficult. Some agreements must be in writing under the statute of frauds, a legal concept dating back to 17th century Britain. This includes contracts involving real estate sales, agreements that cannot be performed within 1 year, promises to pay someone else's debts, and certain other categories. The statute of frauds exists to prevent fraud and encourage careful negotiation of important agreements. The application of these rules varies by state. California strictly enforces its 2-year limitation and requires written agreements for real estate and long-term contracts. Illinois courts have recognized that mixed oral and written contracts may be treated as oral for limitation purposes. Florida enforces a 4-year statute of limitations for verbal agreements. For an oral contract to be legally binding, it must contain the 3 essential elements mentioned earlier. Consider this example. As a woodworker, you offer to build kitchen cabinets for $5,000, and the homeowner accepts. This creates a valid contract without anything in writing. However, without documentation, the other party might later deny the agreement existed. If someone breaches an oral contract, you can pursue legal remedies similar to those for written agreements. These include compensatory damages to reimburse direct financial losses, consequential damages for foreseeable indirect losses, and in some cases, equitable relief like specific performance or restitution. The challenge lies in proving the contract existed in the first place. To strengthen an oral contract, document related communications through emails or text messages. Evidence of partial performance, such as delivered goods or services, supports enforceability. Third-party witnesses who observe the agreement can bolster your claim. Sending a written summary after a verbal agreement provides valuable documentation. Oral contracts are valid in many situations, but they come with significant practical challenges. Understanding the statute of limitations in your state is crucial, as is gathering supporting evidence. While verbal agreements can be binding, the difficulty of proving their terms makes written contracts the safer option for important transactions.